I thought it'd be fun to read the Constitution. I'm sure everybody reads this regularly, as do I. It's we talk about it so much and argue about it so much, and the conservatives are constitutional fetishists. But similar to the way people use the Bible, you get the idea sometimes people haven't actually read it. So here's the Constitution of the United States. It's the original one with links to the parts that have been changed. And there's some features of conservatism at the moment that drive me nuts. Like, you probably think this is a democracy. Yeah, I've read the Constitution. It has democratic instruments that makes it a democracy. No, it's a republic. Republics can be democratic. Well, rule of law, rule of law. Yeah, I know. It's the rule of law. Yeah, exactly. It's not a tyranny of the majority kind of majority. Ooh, it's coming out again. Screw that back in. She's at. Ooh. Oh, fuck. Okay. Anyway, Constitution of the United States. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessing of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Section 2. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. No person shall be a representative who shall not have attained the age of 25 years, and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Representatives and direct taxes shall be apportioned among the several states which may be included within the Union according to their respective numbers, which shall be determined by adding the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, and 3/5 of all other persons. Yeah, that's one of the ones they changed, right? So is it a living document? Ooh, let's argue about if it's a living document. Well, it can be changed. So, so this amendment here, Amendment 14, Section 2, changed that, and says representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when isn't that funny, Indians? But when I didn't know I could not be taxed. But when the right to vote in an election, at any election for the choice of electors for President and Vice President of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any male inhabitant of such state, being 21 years of age, and citizens of the United States are in any way abridged, except for the participation in rebellion or other crime. The basis of the representation therein shall be reduced in the proportion which the number of male citizens shall bear to the whole number of male citizens 21 years of age in such state. What is with all the male reference? Really? Didn't they change that? Okay, back to Section 2, Article 1, Section 2. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such a manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000. But each state shall have at least 1 representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence Plantation 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. So you see the Virginia-Pennsylvania angle there on our colonies. When vacancies happen in the representation from any state, I always try to touch my screen now. The executive authority thereof shall issue writs of election to fill such vacancies. The House of Representatives shall choose their Speaker and other officers and shall have the sole power of impeachment. Section 3. This is fun, isn't it? The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature. That part was changed. Thereof for 6 years, and each senator will have 1 vote. Immediately after they shall be assembled in consequence of the first election, they shall be divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the second year, of the second class at the expiration of the 4th year, and of the third class at the expiration of the 6th year, so that 1/3 may be chosen every second year. And if vacancies happen by resignation or otherwise during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which will then fill such vacancies. So that part going from "and if vacancies happen" to "then fill such vacancies" also was changed. It changed the way that works. You don't have to wait till the next meeting of the legislature and have the legislature fill the vacancies. The states do. Basically, it is, well, you know how it works now. It's state by state, but basically the governor makes that appointment, and then you have a special election. No person shall be a senator who shall not have attained the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. See, when you read the Constitution, you can't just read the sexy parts. You gotta read the whole thing. The Vice President of the United States shall be the President of the Senate, but shall have no vote unless they be equally divided. I saw this guy on Colbert or somewhere, was it Colbert? Talking about, what if you impeach the Vice President? Then he's presiding over his own trial. Well, not really. He's just President of the Senate. I mean, impeachment trials are, I believe we'll get to the part where impeachment trials are overseen by the Chief Justice. The Senate shall choose their other officers, and also a president pro tempore in the absence of the vice president, or when he shall exercise the office of President of the United States. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside. Oh, okay, maybe that guy guessed was correct. I see. The President. And no person shall be convicted without the concurrence of 2/3 of the members present. Judgment in cases of impeachment shall not extend further than removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Section 4. The times, place, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. The Congress shall assemble at least once in every year, and such meetings shall be on the first Monday in December, unless they shall by law appoint a different day. So be on the first Monday in December. That's been stricken. Let's see what they say replaces that. This is at archives.gov, by the way, is where I read it. So let's... the Congress shall assemble at least once in every year, and such a meeting shall begin at noon on the 3rd day of January, unless they shall by law. So they just changed the day. Yeah. Exciting. Section 5. Each house shall be the judge of the elections, returns, and qualifications of its own members, and a majority of each shall constitute a quorum to do business, but a smaller number may adjourn from day to day, and may be authorized to compel the attendance of absent members in such manner under the penalties of each house may provide. Each house may determine the rules of its proceedings, punish its members for disorderly behavior, and, with concurrence of 2/3, expel a member. That's interesting. Each house shall keep a journal of its proceedings, and from time to time publish the same. I mean, I wonder if they should be using that, you know. Maybe 2/3 should judge the third that is screwing things up. Of course, they wouldn't do that, right, would they? So where was I? Each house, section 5 going on, each house shall keep a journal of its proceedings and from time to time publish the same, excepting such parts as may in their judgment require secrecy. And the yeas and nays of the members of either house on any question shall, at the desire of 1/5 of those present, be entered on the journal. Neither house during the session of Congress shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that in which the two houses shall be sitting. I'd like to change that one. I think that they should go in session using, video conferencing and be home. Section 6. The senators and representatives shall receive a compensation for their services to be ascertained by law and paid out of the Treasury of the United States. They shall, in all cases except treason, felony, and breach of peace, be privileged from arrest during their attendance at the session of their respective houses, and in going to and returning from the same, and for any speech or debate in either house, they shall not be questioned in any other place. No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time, and no person holding any office under the United States shall be a member of either house during his continuance in office. Section 7. All bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as on other bills. Every bill which... So, that didn't happen with this fiscal cliff. But it wasn't raising revenue, it was stopping it from automatically being raised. Every bill which shall have passed the House of Representatives and the Senate shall, before it became a law, be presented to the President of the United States. If he approve, he shall sign it, but if not, he shall return it, with his objections to that House in which it shall have originated, who shall enter the objections at large in their journal and proceed to reconsider it. If after such reconsideration 2/3 of that House shall agree to pass the bill, it shall be sent, together with the objections, to the other House, by which it shall likewise be reconsidered, and if approved by 2/3 of that House, it shall become a law. But in all such cases, the votes of both houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered into the journal of each House respectively. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law, in like manner as if he had signed it, unless the Congress by their adjournment prevent its return, in which case it shall not be law. I forgot we have this. We have this in our state. Instead of vetoing a bill, the governor can just decide not to sign it. It becomes law, but they can register their disapproval without, overruling their legislature. They can say, well, I don't want to sign, I don't believe this, but I'll respect the work of the legislature. And evidently that's true of the president. So it's interesting because I hadn't remembered that until I was reading the Constitution again recently. And I'm curious, I wonder what bills have been passed that way, how common that is. Section 8. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States, but all duties, imposts, and excises shall be uniform throughout the United States. To borrow money on credit of the United States, to regulate commerce with foreign nations and among the several states and with the Indian tribes, to establish a uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States, to coin money, regulate the value thereof in a foreign coin, and fix the standard of weights and measure, to provide for the punishment of counterfeiting the securities and current coin of the United States, to establish post offices and post roads, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right of their respective writing and discoveries, to constitute tribunals inferior to the Supreme Court, to define and punish piracies and felonies committed on the high seas and offenses against the law of nations, to declare war, grant letters of marque and reprisal, make rules concerning captures on land and water, to raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years. Interesting. To provide and maintain a navy, to make rules for the government and regulation of the land and naval forces, to provide for calling forth the militia to execute the laws of the Union, suppress insurrection, and repel invasions. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and authority of training the militia according to the discipline prescribed by Congress. I really think we should go over the National Guard, make it so you can't deploy them to a foreign land, or let's say not more than 100 miles from the border of the United States, and well, a lot of people in the National Guard are doing it kind of as a militia. And I believe that, the National Guard's useful when you have a national emergency. To make rules for the government and regulation of land and naval forces. To provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. See, I think it's important that the word militia is in the Second Amendment with the right to bear arms. And this is what I'm saying, where the militia is not there to take down the government. It's there to execute the laws of the Union, suppress insurrection. Right? So, that's what I'd like to see. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of officers, and the blah blah blah. I read that already. I just wanted to go back. I meant to emphasize the calling forth the militia to execute the laws of the Union, suppress insurrections. To exercise, so according to the Constitution, the Congress has the right to suppress an insurrection. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as may by session of particular states and the acceptance of Congress become the seat of government for the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Section 9. Okay, it's only 10 sections. Do Article 2 as a different video. Section 9. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 for each person. It's funny how $10 is just in there. They've never struck that or changed it. So, The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. No bill of attainder or ex post facto law shall be passed. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. Okay, that last clause has been changed. Amendment 16 changed that to the Congress shall have the power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. All right. No tax or duty shall be laid on articles exported from any state. No preference shall be given to by any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. No money shall be drawn from the Treasury, but in consequence of appropriations made by law, and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. No title of nobility. See, I think they failed because they always tell us, we don't know where that billion went. So there's somewhere we constantly are breaking the Constitution. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of Congress, except of any present emolument, office, or title of any kind whatever from any king, prince, or foreign state. Section 10. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. No state. So that sounds like states could make gold and silver coins. Why don't they do that? Couldn't they just in Texas have a gold and silver Texas coin? Sounds like that's allowed. No state shall, without the consent of the Congress, lay any imposts or duties on imports or exports except what may be absolutely necessary for executing its inspection laws, and the net produce of all duties and imposts laid on any state on imports or exports shall be for the use of the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded or in such imminent danger as will not admit of delay. Article 1 of the Constitution.